The Supreme Court jumped into the heated debate over transgender rights Monday. The justices agreeing to hear a case from the Biden administration challenging state bans on gender-affirming care. Wendy Griffith has more.
25 states have passed bans on gender-affirming care, and several are on hold due to litigation. The case before the High Court involves a Tennessee law that prohibits transgender minors from receiving puberty blockers, hormone therapies, and invasive surgical procedures. The Biden administration and some parents claim the law prohibits what they call life-saving treatment.
Yeah, the Department of Justice will absolutely take the position that this is life-saving care. That has been the mantra of this administration from day one of the Biden presidency.
Sarah Parshall-Perry of the Heritage Foundation says the court will be asked to decide if the laws violate the Equal Protection Clause of the 14th Amendment.
The Supreme Court is going to approach the Equal Protection Clause by making a determination of whether or not sex is the same as gender identity and vice versa. Sex has been considered a quasi-suspect class for purposes of Equal Protection Clause analysis, and that requires a heightened level of judicial scrutiny. But gender identity and transgender status have never held to be the same, especially by the Supreme Court, to be the same as biological sex.
Meanwhile, England and other European nations are backing away from transition treatments for minors after studies showed weak evidence that they lead to long-term positive impact.
This is one instance in which I think Europe is headed in the right direction. In addition to that, we are now seeing Norway, Finland, Sweden, and now the most recent addition is Scotland, who has backed off the use of chemical castration agents as well.
There's also a growing number of people who underwent gender transition that are seeking to revert back to their biological gender. They're warning distressed children and their families about rushing into life-altering medical decisions.
So at a certain point, I think the Supreme Court is going to have to reference the fact that this is a highly debatable area of public discourse. It is a political hot topic.
Ultimately, Perry believes the High Court will keep the issue with the states.
There is not going to be a willingness to pluck a constitutional right to experimental medical treatment out of thin air and certainly pull it from the ethers of the Constitution. That is going to be a question I think the judges will find better suited for the state houses.
The High Court will hear the case in the fall, and the justices will rule on the case around this time next year. Wendy Griffith, CBN.